Megan Gorum versus Storm Goodale.
Court will note the appearance of Mr. Bartell on behalf of the plaintiff, appearance of Ms. Sawyer on behalf of the defendant. This matter is before the court on the defendant's motion for appointment of a counselor. Ms. Sawyer.
Yes, Your Honor. I apologize for the lack of presence of my client. Obviously, I'm in a bit of a tough spot. We've had a little bit transpired here. My client is in jail, and I've been unable to reach him. I've reached out to his criminal attorney, but I haven't been able to speak with him. Nonetheless, the original motion was just to make sure that we get a counselor appointed. As we discussed in a previous hearing, we've had differences between myself and opposing counsel. Our position is that it should be a counselor from either Bronson or Borges Hospital who specializes in children. Doesn't necessarily have to be sexual abuse, but we do want somebody who specializes in children, and who the reason they've selected Bronson and Borges is simply that covers the health insurance, so that whether or not the proceedings go forward or not, this is a counselor that the child would be able to proceed with long term.
Okay. Mr. Bartell, I did receive your answer and review that. Anything else you'd like to add?
Your Honor, I just note we just want an independent counselor here. We don't agree with the Borges Bronson because that all started about this whole sexual assault services when there's never really been any allegations of that. It was originally physical allegations that their CIT was done. Sheriff's Department investigated, CPS investigated, they unsubstantiated anything. The child denied it. It was all closed out. And even this court had ordered that the counselor be mutually agreed upon. And that same date that this court had that last hearing, defendant took the minor child still to, I think it was Bronson. And so we just think it shouldn't be connected there. We just ask the court use the list that it normally uses.
Okay. Well, what the court did when I ordered it to be mutually agreed upon, that's what I mean. So if you can come to an agreement, if not, then bring it to the court. But I'm not going to appoint someone that's previously been involved in this particular matter that might be in some way tainted by either the parties or, prior actions. So I'll leave it up to the attorneys to agree upon a counselor that has not been utilized before. And hopefully you can come to that agreement. And then I'll ask that Ms. Sawyer that you would submit the order if you come to an agreement. If you can't, make a list of counselors and bring it. You can each submit a name of 2 counselors and bring it back before the court, and I'll make a decision. Okay, thank you.
Sounds good. Thank you,
You're free to go. Have a good day.
Thank you.
Jennifer Novis versus James Novis.
Court will note the appearance of Mr. Bartell on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for exclusive use, custody, supervised parenting time, and other relief. And the court notes that, again, the defendant is not present. This matter was set for 9:30. It is now 9:56. Mr. Bartell, anything else you'd like to state?
Well, yeah, I'll state for the record, Mark Robinson had told me as of about 3 weeks ago that he was representing the defendant in this matter. And so there had been some back and forth. There was actually an agreement that we came to. I circulated a proposed order last week. He said, "Oh, it looks great. I'm going to have my client in." I said, "Oh, I'm going to proceed forward, if I don't have it signed." So we're here. I guess I haven't received an answer. I know there's not an appearance by Mr. Robinson in there. When we renoticed this hearing, we sent it to Mr. Robinson and his client. So I'm just trying to be upfront with the court. I don't know if the court wants me to submit what Mr. Robinson in an email had said he was okay under the 7-day. Otherwise, I'm just kind of sitting here.
Okay. Mr. Bartell, I guess the one thing I'll ask, because I have some notes as to what the court was going to order, but did that order provide that the plaintiff would receive the adoption subsidy in lieu of child support?
Yes, it did.
Okay. Why don't
my client would? Yeah.
Yeah. Why don't you do this, Mr. Bartell, submit that order that you were going to enter with Mr. Robinson, submit that under the 7-day, and the court will enter it.
Okay, I'll do that. Thank you.
Thank you. Have a good day.
All right, have a good day. Thank you.
Justice Pugh versus Devontae Miller.
Court will note the appearance of Ms. Reed on behalf of the defendant. This matter is before the court on the defendant's motion for parenting time. Ms. Reed, you'd ask also for communication through our family wizard, which the court will grant. And you've asked for parenting time every weekend from Friday morning through Sunday at 6. Is that accurate?
That is accurate, at least until the evidentiary hearing can be held in this matter, and that evidentiary hearing has been scheduled for March 6th.
Okay,
And since we filed the motion, my client did have parenting time for the last 2 weekends, and they're kind of doing like extended weekends based on however the parties agree. But we are asking for an interim order because there was a period where she cut off contact.
the court will grant that particular relief on the weekends, as well as communication through our family wizard. And you can prepare the order and submit under 7-day notice of entry.
The child's birthday is tomorrow, and he's requesting some birthday time. Is that possible?
I'm not going to get into those nitpicking things at this point. We'll address that at the hearing.
Okay,
You're free to go. Have a good day.
thank you.
Peyton Fry versus Jacob Risky.
Court will note that this matter is before the court on the defendant's motion to set aside referee order in this matter. Mr. Brisky, you can proceed.
I would just like to say that the amount that was given, I cannot support myself and my bills as well as pay that amount every month.
I note that's what you basically, your objection is that you couldn't pay the support. Ms. Frey, is there any response you have to the motion?
No.
Okay. Well, in this matter, Mr. Brisky, what you have to understand is child support is set based upon child support guidelines, which is established by the state legislature. It's not set by the court. It's not set by the front of the court. The state legislature puts that in place, and they only allow the court to deviate under extremely limited circumstances, none of which are applicable in your case. So what happens is the court's not going to be able to deviate because the court can't, based upon the facts in your case. So the court is going to have to unfortunately deny your motion at this point to set that aside. So it's unfortunate, sir, but if you have your only recourse is to go to the state legislature and get them to change the law. So thank you. You're free to go. Have a good day.
Shania Roman versus Sebastian Roman.
Court will note the appearance of Ms. Moss on behalf of the plaintiff, Mr. Todd on behalf of defendant. This matter is before the court on the plaintiff's motion for temporary custody, parenting time, and support. Ms. Moss.
Good morning, Your Honor. Thank you. We had hoped to settle this in mediation last week, but unfortunately that wasn't able to take place because of defendant's failure to pay the cost. There is currently a temporary order in place. It was a stipulated order with week on, week off parenting. There was no provision in that order regarding legal or physical custody. So there's no need here to show good cause or a change in circumstances was suggested in defendant's motion. Since that temporary order entered, defendant has been unable or unwilling to exercise his parenting time of week on, week off. He occasionally has the children for the weekend of his week, but generally only if plaintiff initiates or facilitates that happening. Plaintiff is very much willing to facilitate defendant's parenting time. However, there's a PPO in place in this matter, so we would like a court order so that parenting time can be complied with pursuant to a court order so that the PPO is not violated. Plaintiff is and has been the primary caregiver and provider since birth and before and after the separation of these parties. Defendant's involvement has been minimal and limited. Plaintiff provides food, clothing, transportation, pays for daycare. Defendant did note that he provides for the children when they're in his care, but I can only assume that that involves feeding the children, as my client provides for absolutely everything else. Defendant has never been involved in the decision-making of the children, and the sole ECE is with my client. Regarding our request for sole legal custody, this is a case where the history of domestic violence warrants a finding that sole legal custody should be with my client. Defendant repeatedly sexually assaulted my client in their bed with the younger child in the bed, demonstrating that he cannot make decisions in the best interest of the children. He also dragged my client to another room, and when one of the children tried to follow, he pushed the child. This is the basis of the PPO that is in place between the parties and shows that defendant isn't making decisions in the best interest of the children. Also, defendant has not been involved in the decision-making for the children, doesn't attend doctors, hospital visits, or dentist appointments. My client estimates that over 5 years, he's attended 4 doctor's appointments. My client is the one who makes sure they have insurance, that those appointments are made, and that the children get to those appointments. I believe that there is no dispute that defendants should have parenting time on alternate weekends and that the exchanges should take place at the police department. Alternate holidays, as has been previously agreed upon. For child support, we are asking that defendant's income be estimated at $25 an hour for 40 hours a week, unless defendant is able to provide pay stubs before the end of the day on Wednesday. I also note that defendant says he works 3rd shift, which makes it difficult for him to parent. I'll note that my client also works 3rd shift, but has been able to be the primary caregiver and take care of the children. In sum, we are asking for sole legal and physical custody, defendant to get alternate weekends for parenting time, alternate holidays, exchanges at the police department in Springfield, child support according to the child support formula, and that this order control if there's a conflict between the previous order and this order. Thank
Okay.
you.
Thank you. Mr. Todd.
Thank you, Your Honor. Your Honor, I guess first of all, we would respectfully request any of this new information that was not contained within the pleadings regarding the argument for joint legal be dismissed. Unfortunately, we believe that that's absolutely trial by surprise. None of those allegations were contained within the initial motion, and so I would respectfully request that the court not consider those. We do believe that there's an established custodial environment with both parents, as evinced by the stipulated order. Had there not been an established custodial environment with both parents, the opposing party wouldn't have agreed to have every other week. And additionally, the parties prior to separation equally participated in child rearing. So we do believe that there hasn't been good cause or change in circumstances sufficient to revisit custody and parenting time. There can be an established custodial environment without an order or with an order. So we do believe that it's with both parents. Since the stipulated order, defendant has lost his job and was facing eviction. A portion of that we attribute to the plaintiff, as he was not allowed to enter that property, but then he was in essence footed with a $5,000 bill. So he needed to deal with that. It's not uncommon for a divorce for people to have difficulty balancing new jobs and living situations. Additionally, unfortunately, my client was involved in an altercation January 1st, where he was assaulted. He needed to spend some time in the hospital. And so obviously it was difficult for him to facilitate exercising parenting time during that. Additionally, my client has tried to be flexible with the opposing party in terms of parenting time in relation to his job schedule and her job schedule. And he believed that that was beneficial for the children. However, we didn't necessarily believe that this motion would be filed and he would in essence be penalized for trying to work it out. We are able to provide verification that he makes $17.50 an hour at Stryker. So we would respectfully request 1 week to be able to provide that information. And we do believe that the current stipulated order should remain in place where the parties remain joint legal custody and joint physical custody and allow this process to unfold somewhat more. In the event that the court is wanting to revisit parenting time, we would simply request that my client be given every weekend to facilitate his new work schedule. But otherwise, we are okay with the stipulated order remaining in place and child support being paid.
Okay, thank you. Anything in response, Ms. Moss?
No, Your Honor, just that my client working the same shift and the same days of the week as defendant, to give him every weekend would be very unfair to her.
Okay. Well, what I'm going to do in this matter is the court is not going to make a decision on custody based upon a motion hearing. Basically, the court's going to require a full evidentiary hearing in this particular matter. So the temporary order of November 5, 2024 will remain in place. The court would, Mr. Todd says they do not dispute or have any problem with picking up and dropping off at the Springfield Police Department. So the court would order that. The court would have the support set based upon the defendant's income of $17.50 per hour. and he will provide, Mr. Todd will provide documentation of that within 7 days of today's date. And otherwise, the rest of the temporary order will remain until we have an evidentiary hearing. So, Ms. Moss, you can prepare that order and submit under 7 days.
Thank you.
Thank you. Have a good day.
Thank you, Your Honor.
Sidney Cook versus Jeffrey Richmond.
Court will note the appearance of Ms. Allstock on behalf of the plaintiff in this matter. The case is before the court today on the plaintiff's motion for temporary custody, parenting time, and support. Court notes is now 10:13 a.m. It was set for 10 o'clock a.m. The defendant has not appeared. So Ms. Allstock, what the court will do is grant your requested relief, granting custody to the plaintiff in this matter. Support would be payable at this matter, imputing minimum wage to the defendant. I don't know, unless we can always review that in the future, should he get involved in the case and provide other documentation one way or the other. The court would, based upon the allegations in this matter, would order supervised parenting time of 3 hours, 1 day a week. That would be either Saturday or Sunday, as the parties could agree. And Ms. Allstock, I'll have you put in how that's who's going to supervise that, because I have no idea at this point.
Thank you, Your Honor. There is one other thing. We do still need to have paternity established. The defendant has acknowledged paternity. He has acknowledged the child, but I do believe that we still need an order of affiliation. I know that the prosecutor's office is involved in this case already, but that has not been done yet.
Well, we'll have to wait that happening unless you file a motion to that extent, because that's not before the court today, so I
Understood.
can address it. Okay, so you're free to go. Have a good day.
Thank you, Your Honor.
Jordan Coolish versus Derica Williams.
Court will note the appearance of Ms. Podolsky on behalf of the plaintiff. This is the plaintiff's motion to dismiss. I'll ask you, Ms. Williams, I did see your answer, and I think it appears that you acknowledge that the pleadings are in error, as they have stated. So why should the court not dismiss it if they're in error?
I agree with the dismissal. Your Honor, good morning. I agree with the dismissal. I just noticed that the plaintiff's motion did not state whether it was with prejudice or without prejudice. I request that the court dismiss the case with prejudice to prevent any future unnecessary legal filings in the future, just due to the fact that I filed a child support case with the court before this case even was brought forth, Your Honor.
Okay. Well, what the court's going to do is, rarely does the court ever dismiss anything with prejudice. So I will not do that. I will dismiss it without prejudice. And if that's an issue in the future, we can always address it at that point. But I will grant the motion to dismiss. Ms. Podolsky, you can submit an order under 7-day notice of entry.
Thank you.
Now conclude it. You're free to go. Have a good day.
Thank you as well.
Roxanne Sullinger versus Michael Medler.
Court will note the appearance of Ms. Podolsky on behalf of the plaintiff. This matter is before the court on the plaintiff's motion to correct child support order to reinstate insurance. Ms. Podolsky.
Thank you, Your Honor. As the court is aware from our motion, a new child support order entered back in 2019. During the 2017-2018 school year, the minor child was actually held back to then repeat that grade in 2018-2019 school year. It wasn't thought about at that time that would then adjust the post-majority support, which it did because she was held back that year. So when she turned 18 in November, support was discontinued. This was done even though a friend of the court had contacted the school district at the beginning of the year to get a graduation date. Unfortunately, the school district put an incorrect graduation date. They corrected it. However, friend of the court did say there was nothing they could do once the support had terminated without further order of the court. Once support terminated, the defendant father then also removed the minor child from the health insurance. So we are asking this court to reinstate the child support order beginning with the December 1st payment. This was done inadvertently. The minor child is still a student. She will not be graduating until this spring. So we're asking for that support order to be reinstated and that the insurance essentially be turned back on for the minor child.
Okay, thank you. Mr. Medler, what's your response? You're going to have to unmute yourself.
I guess I don't understand the held back. It's in sixth grade. If we have a child that's the same age that's graduating actually the same year, that's 3 days older than she is, and he never got held back. So I guess I don't understand. 18. I figured that was the time that the dismissal of child support would be. As far as insurance goes, I have no issue putting her back on insurance. I didn't take her off. It was a child support order with the friend of the court sent into the to our insurance. I have no problem putting her back on insurance as long as she's a full-time student. The thing is that I have a concern about is the 90% payment that they have ordered towards me. I think that's kind of unfair in my part as far as that she is 18 years old.
Okay. Well, what happens, so there is what happens is when your judgment or whatever got entered and your uniform child support order, they didn't include the language which would state that in the event that the child was still attending school on a full-time basis with a reasonable expectation of graduation, that it could be extended to 19 and a half.
Okay.
And that happens especially when kids are held back. And so this is the typical scenario when that occurs. So I understand your issue, and but by the same token, the child still is in, high school, so support would still be required. So the court will grant the motion, which will correct and basically reinstitute, if you would, the support order up until the child graduates. Presumably either in May or June of this particular year. The court will also reinstate and order the child be placed back on medical insurance. And Mr. Medler says he doesn't have any real issues with that. So, Ms. Podolsky, you can put that in an order and submit under 7-day notice of entry.
Thank you.
Okay, thank you all. You're free to go. Have a good day.
You too.
This is
Starks v. Starks.
okay. That was the one that got added. I had it on a different sheet. Different
Devin, can you hear me?
Yes, I can.
Calling case 2019-482 DM Devin Starks versus Jesse Starks. Today is Monday, January 27, 2025 at 9:24 a.m.
Court will note the appearance of Ms. McNiff on behalf of the plaintiff. This is before the court on the plaintiff's motion to modify custody. Obviously, Ms. McNiff, the court's not going to modify custody without having a hearing.
Absolutely.
Although I do note, based upon what you have put in the pleadings, and I'll rely upon those, as a result, what the court will do is will temporarily place Lexi with the plaintiff pending that hearing in this matter. And the court would order that she would be entitled to supervised parenting time to a supervisor agreed upon between the parties in the interim.
Very well, Your Honor. Your Honor, I also forgot to ask if the court would prohibit the use of illegal substances during parenting time. It seems like a no-brainer, but
yeah. Yes, the court would include that in the event that she does have the supervised parenting time, that she would not consume any illegal drugs at that point.
very well, Your Honor. I will prepare that and submit it under the 7-day.
Okay, thank you.
Thank you, Your Honor.
Terrence Butler versus Christine Gray. Today is Monday, January 27, 2025 at 10:37 a.m.
Court will note the appearance of Mr. Wood on behalf of the defendant. This matter is before the court on the plaintiff's motion for modification of temporary parenting time and support. Mr. Butler, go ahead.
How you doing, sir?
Good.
I would like to ask the court to modify the current parenting plan of our daughter Isabella. Based off of my third shift schedule. The reason for this modification is to ensure proper care can be given to Isabella from her father, as the current parenting plan isn't practical based on my third shift hours. We both share joint physical and joint legal custody. I will be officially going to first shift on February 4th from 7 a.m. to 3:05 p.m. I am asking the court to grant a 2-2-3 parenting schedule, as it is in the best interest of a child to consistently be cared for by both parties equally. Also, I would like to ask the court for a recalculation of the USCO to reflect the change to overnights if granted a 2-2-3 parenting time schedule.
Okay, thank you. Mr. Wood, any response?
Well, yeah, so to stay as is. The change that the dad's talking about was something even his own motion he was considering, over a year ago. And I think that's even before the child was born, but this had been a part of what had been anticipated and could have been handled and addressed in the current order. Because he saw this coming. This isn't a new change that was unexpected or a shift that wasn't available before. Well, when I say shift, I don't mean a working shift. I just mean a shift in the schedules. And then I know that he didn't bring it up, but he did allege this domestic violence issue. My client has pled not guilty in that matter, and that matter is still pending. And I'd like that matter to be resolved before it makes any ruling related to that. But we'd like the order to stay as is.
Okay. Well, at this particular point, the court does note that the plaintiff has alleged a basis pursuant to Shade v. Wright for an evidentiary hearing. So the court is going to schedule this matter for an evidentiary hearing before the referee. And so you will be getting notice at some point when that occurs. And she will need to be available for that, Mr. Butler and Ms. Gray. So at that point, the referee will contact you probably within a week to give you a hearing date.
Okay, so does that mean that basically I'm still on my same parenting time schedule?
It means we're doing nothing until that hearing. That's correct.
And that's on February 3rd? Or no, until we okay, I got you.
Until the referee schedules it. I don't know when they're going to schedule.
I got you. Yep.
Thank you. You're free to go. Have a good day.
Elena Ritter versus Redmond Ritter.
Court will note the appearance of Ms. McNiff on behalf of the plaintiff. This matter is before the court on the plaintiff's motion to hold defendant in contempt for violation of parenting time. Ms. McNiff.
Your Honor, this is fairly simple. My client had the party's children during the Christmas vacation for the Monday and Tuesday, December 24th of the vacation. After that, Mr. Ritter had the children, and then he retained the children for the remainder of the Christmas vacation and would not let my client have the children for her portion of the Christmas vacation. So we're asking that this court hold him in contempt and also grant Ms. Ritter the children for Christmas vacation 2025 and grant their father the Christmas Eve that he would normally have for 2025.
Okay. Okay. Mr. Ritter, what's your response?
I would like to motion for an adjournment for legal counsel.
Okay. Well, the court will adjourn the matter for 1 week so that you can have counsel present, and we'll address it at that point then. Same time.
Thank you.
Thank you.
You want me to renotice it?
No, we'll just put it back on for that date.
Thank you, Judge.
Corey Gay versus Nicholas Blasky.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court. This matter is before the court on the defendant's motion to set aside the referee order. Quite frankly, Mr. Blasky, when I looked at the order, I couldn't figure out what you are objecting to. So maybe you can enlighten me.
I think it's too high. I can't afford it. And she has a job now too, and I don't understand why the child support's so high.
Okay. Ms. Gray, do you have any response?
No, but I don't know if I can do this here, Your Honor, but I am requesting for overnight stays when Mr. Blasky does have my children.
You're going to have to file a motion for that. It's not part of these proceedings. So.
Okay.
Okay, Mr. Magnuson, maybe you could enlighten me.
Yes, Your Honor. Just sort of going through and addressing the concerns that were brought up in the objection. One of the themes in this is that there was no attention paid to the other child. That's actually not the case. The case does consolidate, the order does consolidate the cases on page 3 of the order. The consolidation paragraph takes care of that. And by order of operation, the friend of the court will consolidate those and essentially run a 2-child guideline. So those concerns are being addressed in the order itself and will be addressed. As far as the health insurance, my notes indicate there was no mention by the defendant of any healthcare coverage that he has the child on. If that's been a change since the hearing, I would submit that he could file a motion and get that to change. He does mention deductions, things that he pays, union dues, and those types of things, which the guidelines do provide for. My notes indicate, and my review of the guidelines that we created indicate he was credited for $63 a month in union dues, $50 a month for his tools that he pays for, and the referee credited him for boots/uniform expenses of $300 a year. He talks about the income tax and all of that, the withholding that was accounted for in the guideline. That's pretty standard. And he also indicates his rent and his commute expense, which unfortunately the guidelines don't provide for. So I think everything was covered in the order. I guess the main thing is to let the defendant know that the other child is to be accounted for. That's in the order itself with the consolidation language.
Okay, thank you. Do you understand that now, Mr. Blasky?
Yeah, does it matter that she has a job or no?
Well, I don't know what they calculated or took into place at that particular time.
Nothing.
If that's something that happened after that hearing, then you'd have to file a motion and
That's why I filed.
well, apparently you've had all your well, yeah, but when you file in the future, state what you want, because when I read your objection, I had no idea what you were asking for or alleging, because you didn't allege anything about her having a job now. You didn't allege that you have health insurance now. You just had a general objection that you can't pay it and you felt it was not correct. That doesn't tell the court anything. So do you have health insurance on the kids?
Yeah, Blue Cross Blue Shield.
Okay. What I'll do is, why don't you file a motion again, Mr. Blasky, with the referee and state that that you do have health insurance, that she is working, that you have these deductions, and spell it out so the referee can look at that. And then the referee may modify it, or the referee may simply recalculate it based upon the information that you've provided, but likely is going to have some sort of a modified hearing in this particular matter. So
What if I have no idea how much she works or what she gets paid?
well, just you can cite where she works, et cetera, and then at that point she can bring in the information concerning her employment, or you can subpoena that if you wish to do so.
Okay.
Okay,
Yeah, so does this, so I have to redo this whole thing?
you're going to have to file a new motion and set it before the referee, because the referee was the one that heard this. And so set it before the referee, and the referee will take another look at it at that time.
Yeah.
Okay, thank you. Free to go. Have a good day.
Thank you, Your Honor.
This matter is before the court on the plaintiff's motion to set aside referee recommended order. I guess I would state, so the parties are aware, the order shows that neither party appeared at the hearing back on December 20, 2025. When you don't appear at the hearings, this is what happens, because you're not there to present any evidence or address the issue. So, Mr. Siddall, why were you not there?
Sir, I was at work that day and we had an emergency call and I did not hear my phone alarm go off to tell me that I had to be there.
Yeah.
So I do apologize for that.
Well, what I'm going to do, I'm going to refer this back to the referee. to have some additional hearing. Because from what you've stated, there's some substantial things that the referee has to consider, but I will tell you, this is the last time I won't refer to the referee again, so appear at the hearing or else that order will stand.
Okay.
Okay?
Yes, sir.
Thank you. You're free to go. Have a good day.
Yep. Thanks.